Hello and welcome back to the Private Client Podcast. For those tuning in for the first time, I'm Charlie Shammy, an independent financial advisor at Glarms IFA and co-founder of the Private Client Network. We're a networking group for private client professionals trying to close the gap between our various professions. We aim to increase our knowledge, improve the services to our clients, and grow our respective businesses. Today, I'm delighted to be speaking to Darren Kidd, partner at law firm Clarke Willmott. Since completing his degree in jurisprudence at Oxford 18 years ago, Darren has worked in several firms, specializing now in financial services disputes. Darren, thank you very much for joining us.
Thank you for having me.
We were just talking about it before I hit record, but tell me about financial services disputes. Who is disputing and what are they disputing?
So the cases that I'm involved with typically involve disputes in the financial services sector. So, for example, it could be a dispute involving the mis-selling of a financial product, where a private client has a dispute in relation to perhaps a loan or some tax incentivized investment, or something more complex, such as a derivative contract. Typically, the other side to a dispute is either a bank or another large financial institution, or it could be a smaller firm of independent financial advisors. But
Yeah, and I think the financial advisors listening will be quite interested to see where it goes wrong. I mean, from an advisory point of view, all financial institutions, it's probably the same principles I would have thought around each, maybe disclosure or appropriateness. Is that the type of things that firms are getting wrong?
That's where often you can find disputes. So in a financial mis-selling claim, it's looking at what advice was given, and the test really is whether that's the advice that a reasonable advisor would have provided. So you need to be issues that come up in these sorts of disputes are whether the relevant investment was suitable for the relevant investor, whether it was suitable for their needs, whether the advisor carried out sufficient due diligence in relation to whatever the relevant investment is. Did they inform them of the risks, and did they ensure that the investor understood those risks? Those are a lot of the issues that typically come up in the cases that I'm involved with. And yes, disclosure, that's a big part, is one thing that will, in English litigation, you have a cards on the table approach. So one thing that you will be poring over is, well, what was the advice that was provided that the individual has seen, but also what documentation the individual has not seen. For example, all of the due diligence that was done by the advisor in relation to a product, that would be something that would be, generally speaking, available in disclosure as part of testing the case.
Yeah, it makes sense. It's interesting because there's a whole raft of regulation that's just come in our world called consumer duty, and testing understanding is part of it. And in some ways, it's a challenge to know where to go, because obviously we study for a long time. The sort of level of knowledge that you need on any given subject can be quite deep. So it's trying to, I guess, pass on the relevant high level facts that investments can go down as well as up, that you can lose money. It's sort of mind-blowing, to be honest, that there are cases where firms might not be accurately or appropriately disclosing this, or even advising inappropriately, because I guess why do it?
Well, I suppose if you're depends what, it might be remuneration related in terms of perhaps commissions from the relevant providers of products that you're recommending. But, many of the financial planning firms, for example, investment managers, are advising on relatively safe investments. It's talking about ensuring that you're investing in ISAs and that you're maximizing your pension allowances, etc. It's where you have where I get involved is typically where you've got the more higher net worth individuals who've perhaps got more disposable income, and where to put that. They've done the plain vanilla financial planning. What can they do there? For example, one case I did several years ago now was a very large group action where I was acting for several hundred investors in film finance
Yeah.
partnerships. They were very popular amongst sort of high net worth individuals in the early 2000s. Essentially, the people were encouraged by the then Labour government to invest in the British film industry, and tax incentives were offered for those who were willing to do so, and many people did. They were higher risk investments. There was a dispute between the parties as to exactly how high, whether indeed they were high risk, but people were putting quite substantial sums of money into those film schemes, and ultimately, in the litigation I was involved with, they didn't receive the tax benefits that they were anticipating. And the dispute was essentially around, well, where does the fault lie there? Does it
Yeah.
lie with the person who put the partnerships together? Does it lie with financial advisors, in some cases very large investment banks who recommended their high net worth individuals to invest? Or does it lie somewhere else? Indeed, perhaps with the investor themselves, and they took a risk, and the risk eventuated. So that's sort of an example of the type of case that I do, where you've got that more sort of generally less plain vanilla, if I call it that, type of financial planning.
Yeah, it must be fascinating diving into some of the stuff you do. Risk is a really interesting conversation because we talk about it frequently. It's on, from our point of view, it's on all of our emails, and it's something that's discussed a lot. But I think from the investor point of view, or from the client point of view, you can hear it so much. So you talk about risk with large equities, FTSE 100 type stuff, but then when we don't do those type of schemes that you're talking about. But if you're talking about it in the same way, it might seem like the risks are broadly similar, where really they could not be more different. But I think that maybe is not always understood by investors. But frankly, if it's not understood by investors, it really, hold my own profession, it's up to the advisor to make sure it is understood.
Yeah, absolutely. And that was what the allegation was in that case. The example is that the advisors who were essentially sat between the investor and the promoter of those film partnerships, those who essentially put them together, the allegations were that they hadn't sufficiently carried out due diligence into the partnerships. I'm generalizing here,
Yeah.
and informed clients of the risks and understood that their clients understood those risks. That was essentially the allegations. That was disputed, but those were the issues that we were grappling with in that case.
Yeah, it makes sense. I've kind of dived in straight into what you're doing right now. But if we could rewind ever so slightly, getting into all this, being a solicitor, is something you always wanted to do?
It was. You reminded me that I'm getting on a bit now. I finished university 18 years ago.
Yeah.
Thanks for the reminder. I did. It was something that I knew from quite an early age, actually. I was fascinated in reading sort of novels like by John Grisham and things like that when I was, I don't know, latter part of primary school and early secondary school. And I enjoy the idea of problem solving is perhaps one way of describing what I do as a litigator, but just trying to get to the bottom of a story and trying to piece it together and help people resolve their issues. That's something that was quite interesting to me, and kind of that maintained really throughout school and university. Some people find their way into their profession. For me, it was kind of something that I always thought I wanted to do. I had ideas of being a doctor at one stage, but that was maybe when I was 10 years old.
Yeah.
I think from then on, the law was what interested me, and yeah, that was kind of how I started on that track to where I am today.
You mentioned before we started recording that before you were dealing with sort of financial services litigation, you were doing more general corporate disputes.
Yes.
How did you find that change from sort of representing corporates to representing individuals?
It's an interesting one. With representing individuals, you realize just that it is very personal for them compared to perhaps representing an institution where you're dealing with the general counsel of perhaps a very large organization, where of course it's important to them, but personally, it's less important where you've got individual clients. And one of the challenges with sometimes with representing private individuals is they're very passionate about certain things, in particular if they feel they've been misled or something like that. And managing clients can be a challenge, but your job is to try to focus them on what are the key issues and what is going to help them to reach a resolution of their case. So it has challenges. That's not to say acting for a very large company is not challenging, but I think that they're different challenges. When you've got somebody who's very personally invested in the dispute that you're helping them with.
Yeah, it makes sense. And I guess the moment that you're interacting with private clients, it's probably, well, it's kind of they're probably in a heightened emotional state compared to other sort of circumstances where, sort of, for example, what we do, sometimes you get people in an emotional state, maybe post-divorce, post-bereavement potentially, but generally speaking, people aren't. Whereas I imagine a lot of the time, if they're coming to you in a case where there has been significant loss, it's going to be very personal and quite emotional, I would have thought.
Yeah, absolutely. Often I'm dealing with individuals who've lost very substantial sums of money, hundreds of thousands, millions in some cases, and then they've got the litigation is not a stress-free form of dispute resolution. It can take a long time. It can be expensive, and clients often have got to be putting up further capital to try to right the wrong they consider that they've suffered. The other issue with litigation as well is that you generally speaking are liable for the other side's legal fees if you lose as well. So that's another sort of financial issue that private clients have got to think about. Now, there are options in which you can potentially insure against those sorts of exposures, but it does add to, I think, to the stress that private individuals who already find themselves in a difficult situation.
Is the reverse true? If the claim is successful, the legal fees for the client will be covered by the financial institution?
That's right. It's typically you don't recover 100%. Often the court will assess the fees to see whether or not they were reasonably incurred. Or in a settlement scenario, you might reach an agreement with the other side. But generally speaking, you would recover the majority of the legal fees that you incur, but probably not 100% of them.
Yeah. Yeah. Oh, it must be challenging. I do feel for people in that situation. And probably you probably get a really tainted view of the industry as well, because you always see it when it's not gone so well. Whereas
yes.
whereas
yes,
you don't.
but yes, indeed. But then there are many advisors out there who are doing good work for their clients, and indeed in some of the cases that I get involved with, I do work with other financial advisors because, as I think I mentioned earlier, one of the issues that you need to prove in a professional negligence case against a financial advisor, for example, for a mis-selling case, is that a reasonable advisor would not have done what they did. So that raises the question as to, well, what would the reasonable advisor have done? And quite often, cases that I am involved with involve the input of experts who will look and assess for example, the investment and what a reasonable advisor would have done. So often I'm dealing with other financial advisors about what they would have done in a situation, whether
So you do get
the realm of what would have been appropriate to recommend to that client with those circumstances.
Yeah, and I mean I've not done it, but I imagine it's relatively straightforward to assess. I could be wrong, but I think someone who's experienced, I don't think it would take a tremendous amount. The thing is, you have to look through all the communications, I guess, so it could take a while. But to assess appropriateness shouldn't be too hard. If you've been doing it a while, it's quite clear when something's genuinely inappropriate and just shouldn't be done. It's interesting, because we occasionally do get clients who come from other advisors and because something's gone wrong. So so I do sort of see this a little bit. And our first port of call in that situation is raising a complaint against the other firm. And then if that is rejected, we go to the ombudsman. How do you, is that the same for you? Will you go to the ombudsman first? Will you help with a claim there? Or do you go straight, or do you have to wait for the ombudsman decision before you can get you in, before we could get you involved, for example?
You you're not obliged to go to the ombudsman, but many people do, and I think the ombudsman's uh, limit now is £415,000, or maybe 425 now. I think it recently went up. It's a very substantial sum of money, and that may well cover the majority of disputes that cross advisors' desks, where they have a client that they're taking on, where they spot something, where there's some issue with some form of advice that they received from somebody else. So the financial ombudsman is one route to that. Typically, the cases that I'm involved with are where the losses are in excess of that cap. So the benefit of the FOS is it's a free service. Obviously, you may have a professional representative like a solicitor who will help you. But if you're in a situation where your losses far exceed that, then you probably would likely go straight to litigation. You would,
Yeah.
in a similar way that you would raise a complaint with a financial institution, you would write a letter before action, typically setting out the allegations, and hopefully you could resolve it amicably without the need for litigation. But if that's not possible, and you're looking to recover losses, north of perhaps £500,000, so higher than the cap of the FOS, then litigation would be the logical route, I think.
And does that prejudice the claim in any way if you accept a ombudsman decision? Does it stop you then pursuing for higher amounts separately?
If you accept the ombudsman's decision, then that's the end of the matter.
Okay. Well, that's quite a key detail.
That it is, and it's quite an important decision. Obviously, if the ombudsman finds against you, then you are unlikely to accept it, I suspect, if you want to keep your options open. So that would be a consideration that you would need to think about once you had that final decision from the ombudsman.
Yeah, I see. What sort the corporate stuff that you were doing prior? What kind of work was that?
What's a variety? So trying to think now. I worked on a very large insolvency relating to a telecommunications network, which involved a lot of intercompany disputes where the company was in administration, liquidation. So fair bit of insolvency related work. Then it could have been more just breach of contract claims, contractual disputes between commercial parties, not necessarily in the financial services sector.
Yeah.
In relation to supply of goods and services. Just trying to think of other cases. Professional negligence claims against solicitors. Actually, I did quite a few where I was actually representing solicitors who were facing claims, whether that was in relation to property transactions, corporate transactions. So I did some of that sort of at the more early stage of my career.
It's interesting. It's a real mix of stuff. It's a real mix of stuff. My mind keeps going back to the financial services stuff because it's my world a little bit. On appropriateness, here's a question. There's a lot of appropriateness come down to proportionality of an investment. So for example, an investment that goes to zero, had it been 2.5% of a client's overall position, it would be classed as appropriate. But because of the size, say I don't know what limits you'd have for it, but the size of the investment relative to the overall wealth was the bit that made it inappropriate. Could that be part of
Yes, that could be, and that was an issue in that film scheme case I mentioned. So you've got to focus on the client, their personal circumstances, and yes, what percentage of their portfolio they are investing in is relevant consideration. If you decided to put 80% of their portfolio into some very speculative investment, then that's likely to be where questions about negligence are going to be asked. But as in your example, if it's a couple of percent, and you have a client who is perhaps a moderate, it is said they're a moderate to higher risk, they have a higher risk appetite, then that may well be appropriate and suitable for their circumstances. You need to focus on on the client and what is appropriate for them. What is their financial plan? What are they looking to do and achieve with their capital?
Do you get approached by people that present a case and you can almost screen it in that initial, like sort of just in the initial description, I guess, say to them, like, I'm not sure you have a valid claim here. Are you sure you want to pursue this? Like, does that conversation happen as well?
It does quite often. I mean, we essentially have a screening process where we do get a lot of people contacting us. Quite many people contact us directly through our website with an issue, and sometimes I can look at it pretty quickly. Well, I can read what they say and say, I don't think this is something that we can help you with. And I think it's important to be honest up front if we can't. Then there will be those where I look at the initial sort of description and think, well, there might be something in this. And the next step would then be to have a look at the documents. And it might be at that stage I say, I think this is very difficult. And it may well be I'd say I wouldn't recommend you take it forward there and then. Or if they do, make them aware that there will be challenges. And then there will be those cases where you look at it and you think, well, there looks to be something in this, and this is probably worth you spending some money on pursuing. At least, as I mentioned, in that pre-action stage, where the first step with what I do is not just to issue a legal claim in court. Sometimes there is a need to do that if you have a time limit issue. Generally speaking, you have 6 years in which to bring a claim. There are exceptions to that rule, but that's the general rule. So if I've got somebody coming to me saying I've got a problem about some advice I received 6 years ago, and I think there's something in it, then I might be recommending that they put in a claim into court quite quickly, just to protect themselves. Or the other option would be to you can contractually agree with the other party to suspend time effectively to see whether you can resolve the dispute without the need to go to court.
That's interesting. So it's the moment that the sort of complaint or filing is logged, that has to be within the 6 years. But then obviously if the case progresses beyond that, there's no issue there.
Yes, as long as you file your claim within 6 years of the relevant date. And there's a whole raft of case law as to what is the relevant date, because indeed in relation to investments, the world that you're in, is it when you make the investment? Does that when the 6 years start, or is it actually when you realise that you've got a problem, which may well be not until a lot later down the line?
Yeah, often.
Now that is quite a difficult legal question. Generally speaking, the 6 years starts when you make the investment, because that is when you're sort of locked into what you've done. But there is an exception whereby you don't have the knowledge to actually bring a claim until further down the line. And generally speaking, that date to bring your case.
Yeah.
As I said, there's a whole raft of legal cases, which I suspect a level of detail your listeners wouldn't want to hear. But those are the sorts of issues that I have to think about quite early stages when people approach me about potential claims.
I suppose, like all of this stuff, the specifics of any case matter, how and what and when and why and such. It's like coming off the technical side of it slightly. When you deal with other private client professionals, so do you get referrals from financial advisors that may, because I suppose sometimes we see clients after they've left other firms. Do you get brought in from tax advisors, financial advisors? Are they the ones that approach you rather than the client, or is it generally direct approaches from individuals?
It's a mixture. Quite often it is from professional contacts. where, for example, that situation you mentioned where you take on a new client and you're assessing their portfolio and you look at something and it's like, I'm not quite sure why you're in this, or something historical has sort of come up where I don't know if it's tax related, they might have had a letter from HMRC. So quite often professional contacts will get in touch with me to say, I've got a client that there is this issue. Do you think this is something you might be able to help with? And that's, that's something that we will have a look at and see if it is something that we can help with. So quite often it is professional contacts who sort of IFAs, other financial advisors who recommend clients to us. Indeed, they're in a way it's for their benefit because they're obviously trying to help their client as well resolve an issue they've got. And indeed, sometimes I work with the new advisor because, as I mentioned about the expert input, sometimes I might need to understand the product, and they might be able to help me with that understanding, and then I can overlay onto that the legal analysis.
Yeah, no, it makes that makes sense. On the business development side, because it's something that comes up a lot with in the conversations I have with solicitors about when in your career that becomes more of a focus. Is it something you have to spend a particularly large amount of time doing, or is it the sufficient sort of, I guess, flow of work that comes to the firm naturally? How have you found that? Just not just at Clarke Willmott, but at previous places?
I think it's a progressive thing where you sort of you need to do more of it as you get more senior. But I think at a junior level, I think what's important to think about, and this is probably in relation to all sort of professional services firms, is that your contemporaries will always be your contemporaries. Likely they will grow with you, so that if, for example, in my field you become a partner, those that you were trained with many years ago are partners probably at other law firms now, and you've got that professional network that has sort of grown with you, and to maintain that over the course of your career. Generally, in terms of business development, I think the firms I was at, I was doing it from a relatively junior age, but I wasn't leading pitches or things like that. But I was attending networking events. But that, I think, does become more important as you get more senior, and if you're leading a team, for example, and you're responsible for generating the business into to give the work obviously to your team, it's obviously increasingly important.
Yeah. Well, look, it's been really interesting because I deal with sort of day to day. We do interact with solicitors fairly often, and particularly on the private client network side. Law is always really represented at our events, but it typically falls into sort of family law / sort of divorce, and then private client being wills, trust, probate work. So it's been really interesting chatting to you to get an idea of the financial services stuff, because it's honestly, it's not, I don't meet too many people in the field. Well, probably a good thing for other reasons, but I don't meet too many financial services sort of private client solicitors. So it's been really interesting to get your take on that. Where are the rest of them? Why aren't I seeing more of them at the events?
That's a good question, because I mean they are around. I think, I don't know. I mean, there are a lot of them, and I'm not sure where I'm going to do myself a disservice by saying that, but there are, and I think, I mean, a lot of them will be acting for very large institutions. They'll be in the financial services space, but generally they would work on the defendant side, and they would be acting for insurers, banks, etc. So they're not necessarily lawyers who would be acting for private clients, albeit they're obviously in the same space. So there are others who do similar work to me, where generally speaking more on the claimant side, representing private individuals. That's not to say that's exclusive to what I do generally.
Probably a volume thing. I mean, I suppose eventually all of us will pass away, and I think half of us maybe will have some marriage related stuff that needs to be looked at. So maybe cases above the 400k FOS limit, maybe they're not just quite as frequent. But
I think that's fair. That's fair. They're not, those sort of very large cases, they don't come around every day. And when they do, they last for a very long time and keep people busy for a long time.
Yeah, I bet.
So I think that's fair in terms of a volume issue. It's not every day you're going to have a client who's got a dispute for £500,000. Hopefully you don't. So I suspect you're right. And many people do go through the files without professional representative help. And it's a free service to use it. They do it themselves. But I think when you have got something that's a bit more complex and perhaps higher value, then that's where somebody like me can hopefully add value and help.
Awesome. Well, no, thanks for your time. I really appreciate having you on, and hopefully catch you at some of our events soon.
That's good. Thank you for having me again.
Thanks, Darren.